Right now, a stern warning by the Competition Commission that it will go after companies that are profiting or profited from the COVID-19 pandemic. Tsunami Business Enterprises has been slapped with a fine of over 3 million rand for charging the SAPS excessive prices for face masks. Let's unpack this further with the Competition Commission's James Hodge, who joins us now virtually. Thank you very much, Mr. Hodge, for your time. Now, I see that you found out that they charged the SAPS 500,000 rand. This is for how many masks exactly?
So they sold 500,000 masks right at the peak of lockdown as we were going into level 5 lockdown, if you recall, 2 years ago. And they bought those masks for about 17 rand and sold them for over 32 rand. So it's almost a doubling of your cost price. And that we found was excessive. We took it to the tribunal to get an order from them, and they recently came out with a decision saying that they agreed. And as you indicated, they fined 3.5 million rand and must pay that to us. And it also opens up for the SAPS to pursue them.
Exactly. I was going to say that maybe the SAPS should also pursue. What other punishment has been imposed on Tsunami by the Competition Commission? Just the fine, or is there anything else?
No, it's just the fine. So we have a lot of cases from that initial lockdown period where, as you may recall, at the beginning of the pandemic, suddenly everyone was looking for protective equipment, face mask, sanitizer. And in particular, the South African Police Service was in a predicament because they had to police the lockdown with 200,000 officers and had to stock up for those officers within days, literally after the lockdown was announced. So no one supplier was able to supply them. And in fact, this particular supplier, Tsunami, knew full well that they were struggling to get face masks. And so that played in probably into their decision to charge a very high price, knowing that the police service had really little choice. And that's what the tribunal found as well, that the police service had no choice at that stage. Obviously, now we're deeper into lockdown, that position has changed, so there's no need to impose any other discipline on this company. But at the time, that was the predicament that was being faced by every government department.
How many other companies is the Commission investigating because of this exact issue and for that exact period?
So we've already been before the tribunal on another case involving bulk sanitizer to police service, where in fact, the particular firm in question, Blue Collar, was charging more than double what it cost them to get the sanitizer. We're awaiting the tribunal decision on that. But we have numerous other cases of gouging to government departments at a provincial level, a national level, and even the National Health Laboratory Services. So some of these have remained awaiting a decision from the tribunal, but that's why this decision is important. The precedent it sets suggests that this is how the courts will view this behavior, and we hope that we can either prosecute these now more rapidly or reach settlements with the offending parties.
How does the Commission, for instance, come to your 3 million rand fine, etc.? Do you look at how much they were supposed to cost, how many units they sold, and you basically work out how much money the SAPS would have saved? And where does that money go? Does it go back to the SAPS?
So typically there's a cap on a fine of 10% in terms of our law, and only for a second-time offender can it be higher than that. Okay. So in this case, the maximum fine of 10% was levied. In coming to that decision, the tribunal took into account that we had estimated that Tsunami had made excess profits of just over 5 million. So in fact, a maximum fine wouldn't even recoup what excess money has been made. Any fines that are levied in terms of the Competition Act go back to National Treasury. So it goes back to government and can work its way back to the police service. Or as you indicated, positive finding of excessive pricing one can pursue as well for the police service to recoup some of the rest of the monies as well. So ultimately, we're working with many departments to look where they have been exploited, to find, prosecute and recoup some of that money.
So the Commission obviously also fights capitalism, right? We remember what happened with the COVID-19 test when it comes to your clicks and Dis-Chem, and now you're mentioning 5 million and you could only cap it to 3 million. So for these companies, sometimes these fines are nothing, right? So doesn't the Commission have the power, for instance, to blacklist either the company or the owners of the company?
So we cannot blacklist, but it is certainly within the powers of National Treasury and the Police Service to now blacklist Tsunami and not purchase from them again. So you're right, they can face that further punishment. In the case of things like Dis-Chem cases, often it's the reputational damage that companies can suffer too. But as I indicate, the Act has been changed that a second-time offender can be charged up to 25% of their annual revenue, which is a substantial amount of money for most companies. So certainly this should have an important deterrent effect, and that's what we're seeing. Companies don't want to be labelled price gougers in public. They don't want that negative perception, and especially with government work, they don't want to be blacklisted.
All right. Thank you very much, Mr. Hodge, for your time here on eNCA. Of course, those many investigations that the Commission is busy with or waiting for the tribunal to give a go-ahead with. I think a lot of South Africans who are taxpayers are hoping that some of this money is put to good use, because God knows we need it in many aspects in our country.